It's a medical malpractice trial, and now we are in jury selection. We learn that one of the potential jurors knows the doctor whom you have sued. Does that automatically disqualify him sitting in judgment in your case? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is maybe. So now, let me tell you what I mean. We're in a room filled with 25 or 30 people, and now it turns out that one of the potential jurors whom we are talking to knows the doctor whom you have sued. Now, red flags go up in my mind. Why? Because I'm thinking in my mind that automatically this guy is going to be leaning in favor of the doctor. Why? Because he's a patient. He continues to see and treat with this doctor. He puts his life in this doctor's hands. He trusts this doctor. Now, do you think it's going to be difficult for him to tell us in a verdict that the doctor was careless in our particular case? Do you think that this guy, this potential juror, is going to have a conflict in his own mind between the care that he's received and the care rendered to my particular client? The answer is, I believe he will. But that does not automatically disqualify him. Instead, I have to ask questions. I have to probe further. Mr. Jones, tell us, when did you become a patient of Dr. Gonzalez? And now I have to ask more questions. And how has your medical care and treatment been? Have you had any significant problems? Have you had any complications with this doctor? Are you open to the possibility that this doctor may have been careless at a particular date, at a particular time, even though your care and treatment has been flawless? Can you be open to that possibility? Now that's going to be a tough question for him to answer, but I guarantee you he's going to say, no, of course I can be fair and impartial. Really? You are already biased merely because you are a patient who puts your life in his hands. That means you are less likely to believe what we are claiming to be true. Do you think it might be easier? Would it be better for you and less challenging to go ahead and sit in judgment as a juror in another type of case that doesn't involve someone you already know? And most likely he's going to say, yes, it will. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what happens in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not started a lawsuit yet because you have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I answer questions just like yours, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.